particulars of the offence are that on the 15th May 2024, around Narayani Road, in the Backlands area, within Nairobi City County, having been stopped at an official police roadblock, informed number 239729, Inspector of Police, Onesmus Mutua, and number 2393931, Inspector of Police, Yusuf Naiwet, persons employed in the public service as police officers, that you are an officer of the rank of captain in the Kenya Defence Forces, information which could be otherwise prevent the said police officers from arresting you and conducting a search on a motor vehicle registration number KDF 100G Toyota Prado, black in color. The second count relates to the offence of being in possession of papers intended to resemble and pass as currency notes, contrary to section 367A of the Penal Code. And the particulars of the offence are that on 16th day, May 2024, at traffic in Nairobi area police yard in Nairobi City County, without lawful authority or excuse, had in your possession two papers intended to resemble and pass as USD 200 serial number is given there, and the 13 black unmarked papers, knowing them to be forged. The third count is the offence of being in possession of papers intended to resemble and pass as currency notes, contrary to section 324(3), as read with section number 36 of the Penal Code. In particular, on the 15th day, May 2024, at Nairobi City County, had in your possession public stores, namely Kenya Defence Force sticker, the property of a disciplined force, namely Kenya Defence Forces, such property being reasonably suspected of being stolen or unlawfully obtained. The fourth count relates with the neglect of official duty, contrary to section 128, as read with section 36 of the Penal Code. The particulars of the offence are that on the 17th day of May 2024, at Kizito area in Mwihoko, Kiambu County, being a police officer willfully neglected to surrender 14 blanks of ammunition to Amari, a duty you were duty-free bound to perform under the National Police Service. The fifth count is in respect to neglect of official duty equally under contrary to section 128 as read with the section 36 of the Penal Code. And particular sort of events are 17th day of May 2024 at Kizito area in Mwihoko, Kiambu County, being a police officer willfully neglected to surrender 3 tear gas canisters to Amari, a duty you were dutifully bound to perform under the National Police Service. I think you heard what the police officers said, because we had 4 police officers who testified. Let me go direct to my determination. You can get a ruling and read it. The prosecution called for witnesses in ability to establish a prima facie case against the accused, as it were, and in my view, in the review of a host of case laws, the only issue for consideration is whether or not the prosecution has established a prima facie case against the accused persons to be placed under defense. The question is, what's a prima facie case? Prima facie implies that the evidence exists which, unless it is proven, is sufficient to prove a certain fact or circumstance. Evidence that may be accepted as a prima facie case is any evidence which, if accepted at the face value, supports the case or a necessary element of the case. Prima facie case is that amount of evidence which could be sufficient to counterbalance the general presumption of innocence and warrant a conviction, if not encountered and controlled by evidence tending to contradict it and render it improbable, or to prove other facts inconsistent with it, and the establishment of the prima facie case does not take away the presumption of innocence, which may, in the opinion of the court, be such as to rebut and control it. The famous case we usually refer to is Ramanraj Bhatt versus the Republic, where the court said, remembering that the legal onus is always on the prosecution to prove its case beyond reasonable doubt, we cannot agree that the prima facie case is made out if, at the close of the prosecution case, is merely one which, on full consideration, might possibly be thought sufficient to sustain a conviction. This is perilously near suggesting that the court could not be prepared to convict if no defense is made, but rather hopes the defense will fill the gaps in the prosecution case. Nor can we agree that the question whether there is a case to answer depends only whether there is some evidence, irrespective of its credibility or weight, sufficient to put the accused on its defense. A mere scintilla of evidence can never be enough, nor can any amount of worthless discredited evidence. It may not be easy to define what is meant by prima facie case, but at least it must mean one on which a reasonable tribunal properly directing its mind to the law and the evidence could convict if no explanation is given. Now, coming back to the case before me, it is clear that in all the counts, there was a need for, especially in the counts number 2, 3, 4, and 5, there was a need to produce the documents to prove, and also to produce the documents that were recovered and marked for identification, but were never produced in court. And as such, and the absence of those documents, the court will not be able to conclusively decide whether offense was committed. So, if credible evidence is not available or produced by the prosecution, then the term prima facie case does not arise. It is alleged that some recoveries were made from the said motor vehicle KDF 100G Prado and marked for identification, but these documents were not produced. The effect of this has been explained by the superior courts, that when documents are marked and are never produced, they are merely documents which do not land into the court file for the court to consider its veracity. In the case of Justice Musa Wambua versus the Republic 2010, and also in the case of Kenneth Nyaga Mwigi versus Austin Kibuta and 2 others, 2015, this is what the court said, that in the instant case, we are of the view that failure or omission by the respondent to formally produce the documents marked for identification, being MFI 1, 2, and 3, is fatal to the respondent's case. The documents did not become exhibits before the trial court. They were simply marked for identification, and they have no evidential weight. The record shows that the trial court relied on documents marked MFI number 2, that was marked for identification in its analysis of the evidence and determination of the dispute before this court. We are persuaded by the dicta in the Nigerian case of Michael Hausa versus the state that the document marked for identification is not part of the evidence that the trial court can use in making its decision. So that taking cue from this decision, which were never produced, even though they were in existence, they did not become exhibits in the court file. Consequently, when an exhibit, though is in existence, is not produced, instead is retained by those who marked it, the court is entitled, in light of those decisions, to draw an adverse inference that if they were produced, they will have been in favor of the accused persons. In this case, the investigative agencies, either by design or deliberately, lost an opportunity to establish a prima facie case by, for example, producing the recovered USD dollars, the KDF sticker, and the ammunitions from the accused persons, so that all the 3 MFIs, 1, 2, and 3, did not land in the file. Now, the prosecution could have easily established a prima facie case against the accused person if that was done. Ultimately, I make a finding that the prosecution has failed to establish a prima facie case to warrant the accused to be placed on the offense, and I acquit them under Section 210 of the CBC.
Is there not?